It's a pleasure to have you here this afternoon. Special Prosecutor Nominee Kissi Agyebeng says he will make corruption a costly activity for public officials if he's given the nod. He says he will roll out a Pressure for Progress initiative that will review public sector agencies and publish corruption perception index ranking them. He says he will create 2 more divisions at the office. And let me take you back to Parliament, where he's currently answering questions being posed by members of the Appointments Committee. Just gone by, he was talking about the independence of the Special Prosecutor's Office and promised to guard it if given the nod.
To plea bargain by some sorts. A person pleads guilty, he coughs up the money, disgorges himself of the unjust arrangement, and the state is happy to keep the money, enter a sentence of conviction against him, but he doesn't serve a prison sentence. It is not unique. We already have that practice instituted. And clearly, this is meant to put some money in the state covers. What good does it serve? For instance, if you just imprison someone who has hoarded millions for 10, 15 years, he comes back only to go for the money somewhere he stashed it. Better it is to recover that amount from him to make that activity costly. So, Honorable Chair, we already have a precedent in the Cost Act for this.
Yes, the last one is about...
this will be your 4th one.
No, third.
Third.
The last one is about the whole role of the board of OSP. Indeed, I have heard some board members making comments about investigations of OSP. Would you say that, given the role of the board, they should be allowed to make comments on investigations which are being made by the office? And what are the implications of that?
Honorable Chair, the board is not supposed to interfere with investigations and the conduct of criminal proceedings. The SP, the Special Prosecutor, of course, answers to the board. But the Act itself clearly insulates the board from the investigation, conduct of criminal proceedings, and places it squarely in the province of the Special Prosecutor himself. So in that regard, the board should refrain from making comments and passing, let me say, judgment on ongoing investigations, because there is a high risk of a compromise. Leakage of information may arise, evidence tampering may arise, and it is in that wisdom that Parliament insulated the board specifically from initiation, investigation, and conduct of criminal proceedings.
Yes. No, let me give to Zero first.
Thank you, Mr. Chairman. Good afternoon, Honorable Nominee. Good afternoon, Mr. Chairman. Thank you very much for the opportunity, and good afternoon, Mr. Nominee. Mr. Nominee, before I go to my question, please, where is Damfa in Ghana?
At Imensa, you take the right down through Kweman to Damfa.
So that's still in Greater Accra region or Eastern region?
That will be in Greater Accra.
Greater, all right. Thank you very much. Now, my first question to you, Mr. Nominee. In September 2013, at a symposium organized by the Dankwa Institute, you presented a paper And the paper was titled, "The Decision That Wasn't the Decision, a critique of the Supreme Court decision in the election petition case," unquote. In this paper, you argued that the decision by the Supreme Court was somehow erroneous. You argued in the paper that the decision was somehow erroneous. How do you juxtapose that position against the 2021 election petition hearing of the Supreme Court, where the EC chairperson was not made to testify under oath, which was actually central to the position of the NDC in filing that case? What are your thoughts on the Chief Justice's actions in reference to Honorable Dr. Dominic Ayini's comments, which were very close to...
Kindly take it one after the other. You answer one. You're putting two separate issues in one question. Break them up, please.
All right. His comments after the decision, which the Chief Justice took exception to, and was cited before the General Legal Counsel. What is your position in view that your comments, very similar to his, were never cited before the disciplinary committee? Thank you.
Yes.
Honorable Chair, Honorable Ayine is my senior in chambers. Actually, he taught me commercial law, the Faculty of Law then. But I would say here that, before I answer the question, the comments are dissimilar. They are dissimilar in the sense that in 2013, when I was delivering the paper at that symposium, it was an academic paper that I had presented. And my conclusion was that I couldn't find a ratio in respect of the so-called majority judgment in the first election petition case. And my reason was simple. Some issues had been placed before the court. Two main issues, in my opinion, as to whether, number one, the second respondent then was validly elected as president, and number two, as to whether the first petitioner then was validly elected as president. At the end of the day, when I read all the decisions of the 9 justices, I couldn't dovetail it with the outcome that was stated by the president of the court on that day in August of 2013. And this is it. It appeared to me, and as I said, this was an academic paper, it appeared to me that instead of answering the questions that had been placed before the court that day, the court missed those questions and was answering different questions. So whether or not the second respondent was validly elected, that wasn't answered. But what was being answered was, for instance, whether there was overvoting, whether there was voting without biometric verification. So instead of the president of the court stating on issue 1 whether the second respondent was validly elected, president of the court was rather stating how many judges voted on overvoting, 6-3. How many judges voted voting without biometric verification, 5-4, and the like. And to me, as a law lecturer, I didn't know what to teach my students at the outcome, because I'm seeing 5 justices saying that someone was not validly elected, 4 justices saying at the end that someone was validly elected, but I'm being held to say that the 4 justices were in the majority. Because I couldn't find a ratio in that case, that is why I made that academic exposition. And in respect of the 2021 decision, in terms of the comments by my former senior, I actually had cause during the pendency of the first election petition to deliver another talk before this talk you referred to. It was organized by the CDD and the National Media Commission. And there it was in respect of free speech and accountability and the rule of law. If we will recall, several individuals, private persons had been hauled by the Supreme Court and cited for contempt. And my consternation was that it appeared as if immediately your name was cited and you were hauled in before the court, then you needed to start apologizing. And so those who apologized immediately were let off. Those who decided to bring in lawyers to defend them ended up in jail. And that was what I was pointing out in the first paper before this paper you referred to. Indeed, at that time, the bar took umbrage at what I said, but I thought that I captured the conscience of the nation better by saying that, look, this whole issue of contempt as a criminal offense is so dangerous that if we are not minded to codify it, to define it well, and to come up with commensurate punishment, we will get to a situation where it will not be on national TV that day, but a high court judge sitting somewhere in Goso, there's no camera on you, cite you for contempt, jail you for 15 years. All you have to do will be to appeal. So I was sounding that caution, and that where we were going was very slippery road, and so we needed to rein ourselves in.
Honorable, before you come to this, let's go a little back into how did the concept of contempt of court develop? Was it by statute? It was never by statute. No, it was. The courts generated that to protect themselves from executive abuses. Parliament generated its own contempt to protect itself from executive abuses because they have powers, they have the agencies of force. The courts don't have. The Parliament doesn't have. So these two arms of government developed their own jurisprudence of contempt to protect the two institutions. So now, are you suggesting that Parliament should now make rules regulating how the court should now exercise their power of contempt?
Honorable Chair, absolutely. That is what I'm suggesting. It is dangerous, no matter how you look at it, if we are just to leave it the way it is. It is a common law offense, which has been accepted under the Constitution. But the danger, as I pointed out, is that because it does not have defined punishments for it, the punishment at some point may not fit the crime at all. And that is the danger. Because if you were to be cited for contempt today and say the judge gives you 2 weeks in jail, maybe you were let off. Same act placed before another judge may fetch someone 2 years. How do you justify that? It is a simple matter, in my opinion, of just delineating it. Okay, this act amounts to contempt. And in respect of this, if Parliament or the courts were to cite you for contempt and hold you liable, within these 4 corners, we can hold you liable. Honorable Chair, I think it is a safer course to go than to leave it open as it is. There is a clear and present danger.
Well, that's why we continue to have different opinions. But I didn't finish answering her question on Honorable Ayine.
I believe I finished.
You're done. Very well.
Thank you very much, Honorable Chair. Honorable Nominee, my second question has to do with a report by the Center for Social Justice, which suggests that Ghana has lost up to 1.89 billion cedis in judgment debts. There's a school of thought that intimates that these judgment debts sometimes are not particularly due to bad contracts being cancelled, but due to schemes that have been cooked up by senior public office holders, sometimes in collusion with international organizations, with local companies, just to fleece the state. What will you do? How do you think your office, the Office of the Special Prosecutor, can work towards eliminating this canker so that Ghana can save a lot of money? Thank you.
Honorable Chair, I believe I answered this question earlier when I intimated that our institutionalized risk assessment, conducting regular risk assessment in terms of the avoidance of toxic deals. That is what you referred to. These are toxic deals. And also the avoidance of judgment and tribunal award debts. And then I also intimated that I would do a systemic review of public sector institutions and the development of integrity plans. And that is where I waded into my corruption perception index idea of anti-corruption barometer of state agencies. That will have teeth and it will bite.
Thank you very much. My final question. A lot has been said about your age, and you've alluded to your experiences up to this point, which you think will be a good guide for you in undertaking your job in this office. How will you, however, navigate our cultural settings where we revere our elders in society, we revere the big man, we revere our chiefs? In terms of prosecuting your work, somebody is under investigation, goes to see Nana or Bahima, she calls you. How will you manage this within the context of our Ghanaian settings? Thank you.
Practically, simply, I'll have less friends. And that is what I alluded to my earlier statement, that in the society of ritualistic gift-giving, gifts of goodwill, it becomes very difficult. And so just a reliance solely on the criminal law is not going to make it. Some practical, innovative things must come on board. If I start by having less friends, if I start by not picking calls, you will not approach me easily. But I admit, honorable member is fascinated by it. I'll admit that, of course, if my village chief calls me and asks for a favor, it will be difficult. But, sorry? Yeah. It will be very difficult not to attend the call. But I said earlier to in answer to an earlier question that if I place myself within the four corners of Act 959, I should be much more insulated from these things. But if I go out of it, then I open myself up for Jantua.
Very well. Honorable Minister first. Deputy Minister for Education, is that right? Yes. In that order.
Thank you very much, Honorable Chair. Congratulations, Mr. Kissi Agyebeng. It's amazing how you would drop one of my favorite names, William, which also happens to be the name of my father. Maybe you may consider transferring it to one of your prospective kids in the future. But I must congratulate you again, and going through your CV, the sterling legal credentials that you have, and listening to you, particularly on the innovative methods that you intend to deploy in the fight against corruption, I'm confident that you would succeed in the discharge of your mandate. However, there are just two concerns that I want us quickly to address. The first is your predecessor, when his nomination came up, was met with very high public expectations, just as your nomination has also been met with. the public have very high confidence and high expectation in your delivery. However, some have held the view that your predecessor was unable to fully discharge his mandate and even to full term. So what assurance can you give this committee that when given the nod, you will see through the discharge of your mandate fully, and that somewhere along the line you won't throw in the towel should you encounter some challenges?
Honorable Chair, if I see through this office, I will be leaving at the end of a 7-year tenure on my 50th birthday. The gift I want to give myself when I turn half a century is that the OSP, solidly established, methodologically run in its deliberations, and its mandate is firmly placed on the map, that we may even become a beacon for our sister countries in our region to look up to. That's the gift I want to give myself for my 50th birthday. And so, my assurance to you, Honorable Chair, I'm going to see it through.
Very well, Honorable Chair, that would be a good legacy and a good gift, and I would encourage you to pursue so. The second and last concern here is that among many other criticisms that your predecessor publicly raised, one of it is that he alleged against you that you're representing some persons whom are under investigation by the Office of the Special Prosecutor. Now, when given the nod, which I'm confident about, how would you handle such matters in a way that you will not be conflicted? And how would you specifically handle such cases under reference?
Honorable Chair, once again, this appears to be a bit of a flight of fancy. It is not, if I may put it, true to say I represent persons who are before the OSP as suspects. It was in respect of one matter in which my firm represents a company, and the CEO of the company was invited to come and assist the OSP in respect of some investigation and the award of some contracts that the company did not award to itself. On the day that we appeared with the CEO of the company, the OSP could not meet with the person to interact with him. The meeting never came on, and as we sit here, it has never been recalled. So in that context, you cannot say that I represent suspects before the OSP. Once again, as I said, it's a bit of a flight of fancy.
Thank you very much, Nominee and Honorable Chair.
Yes. Thank you very much, Mr. Chairman. I would want to congratulate the Honorable Nominee for his elevation and appointment. As he has said already, he's been one of our favorite lecturers at the faculty. So, Mr. Kissi Agyebeng, congratulations. Now, my very first question has to do with investigation and corruption-related matters with respect to the appointing authority. The government of the day is giving you the opportunity to serve in this capacity. The Akufo-Addo administration has been hit with several corruption-related scandals. Oh, please, these are matters of public. So, for example, we've had contract for sale scandal. We've had PDS scandal. We've had cash for seed scandal. We've had the Kelning GVG scandal. We've had issues of visa Commonwealth visa scandal. We've had issues of Ghana Maritime Authority scandal. We've had issue of the Bost 15 million contaminated fuel scandal. We've had issues with respect to Ameri deal. Now, my question is that how committed are you to investigate corruption and corruption-related matters under this government, particularly when one of the complaints by your predecessor was that government did not give him the support, the needed support, to work as an independent special prosecutor?
Honorable Chairman, Honorable Member, I thought you were going to refer to investigation of any of these specific acts you have nominated, but you're zooming off them to general questioning. Those ones, are you interested that he investigates any of them? Does it come under his mandate? That's what I would like you to. Yeah.
I'm sure his answers would prompt some of those.
Honorable Member, Honorable Nominee, he listed a number of issues he calls scandals. Do they fall under your mandate? Are you interested in investigating any of these if they are still pending?
Honorable Chair, this is what I would say. I would approach all cases of alleged corruption-related issues with the same objective, ruthlessly.
So how do you intend dealing with funding of the and then its associated challenges for the Office of Special Prosecutor? Because I think one of the complaints, again, of your predecessor was that he didn't have sufficient funding. And even though later on we got to know that even the money that was made available was not used by the office. How do you intend dealing with this situation?
Honorable Chair, you know, the first occupants of the seat indeed had no president. He was the first occupant. Before him, there was no one else. So whatever he faced there, I would like to believe were what I'll call teething problems. I would draw from the wisdom of the hindsight of the problems that he faced to chart my own path.
Mr. Chair, as far back as 1970, Justice P.D. Enin reports as follows in paragraph 141 that a deadly virus, he described corruption as a deadly virus that is eating its way into the body politics. If it is not checked and brought under control, it will seriously undermine the effectiveness of the present and the future government of Ghana. And that is as far back as 1970. One of the reasons why the Office of Special Prosecutor was established was to deal with issues of corruption. As we speak today, the corruption perception index is negative when it comes to this administration, and indeed, public confidence in the Office of Special Prosecution has really dwindled. What would you do to increase public confidence in the Office of Special Prosecutor?
Honorable Chair, the last corruption perceptions index by Transparency International, we scored 43, which is actually the world average. And the African average, I believe, is around 32. We are not doing so bad. But we need to go beyond. Yes, it appears we've been a bit stagnant on that trajectory.
But that was a reduction compared to 2016. Very well.
Some of the things that I intend to do, I've already stated, Honorable Chair. And I would like to add that I would also I'll be engaging the civil society organizations, the non-governmental organizations, community-based organizations, and investigative journalists. And in this quest, 9th December is International Anti-Corruption Day. Why can't the office stage a conference annually, bringing together experts, corruption watchers, to assess Ghana's progress? And here it is not a talk shop. That is not what I'm interested in, but a platform for peer review. It is one aspect to assess our progress and to encourage ourselves to go further. And then again, the office itself needs some reflection, because if care is not taken and the OSP itself becomes corrupt, then the battle is lost. And so I will institute internal measures to ensure that there is no abuse and integrity of the office is upheld at all times. I would also engage the Chief Justice and the Judicial Service to accommodate the OSP by pushing for the establishment of specialized courts when it gets to the leg of prosecution, specially trained judges, judicial officers, in order to quite effectively bring an end more timeously and in a better nuanced way in respect of the initiation conduct of prosecutions. I have also thought about, and I'm going to give it a push, why can't we institute, for instance, an academic discipline in applied anti-corruption studies with partner institutions? We must start from somewhere, and building on that, in that general scheme of affairs, the body politic itself will feel that, look, we need to do something about our fight against corruption. The feasibility of the OSP out there engaging in all these activities, and then its legal operations in terms of the initiation and conduct, investigation of criminal proceedings, married together, will go together in assuring what the Honourable Member is asking for. Mind you, I said earlier, Honourable Chair, that we cannot fight corruption solely through the criminal law.
Yes.
Thank you, Mr. Chairman. And let me congratulate the nominee once again. Mr. Chairman, a co-conflict, you said? Mr. Chairman, since receiving the nominee CV, I did some work on him, speaking with a lot of his people that I know who know him. And this is a summary of my findings. But one worries me. You are known by your peers to be honest, principled, a fine gentleman, frighteningly knowledgeable, and loyal. The Chairman, my question to the nominee is, if you are considered by your peers to be very loyal, if those people are found in your net, those you are loyal to, how are you going to deal with them?
Now remember,
Thank you for the glowing findings you made about me. Now my loyalty is going to be to Act 959.
Mr. Nominee, apart from page 1 of your CV that talks about...
Just a minute there. Your loyalty will be to the act or to the state of Ghana?
Invariably, that is it.
No, I just want clarity. The words are not interchangeable by my understanding of it. For instance, even the Constitution, you would owe and subscribe to it. Loyalty to the Constitution, you've just picked an act of parliament. You are an officer of state, and the concern in Ghana, probably what informed the decision of the president to appoint a special prosecutor, is the inability of political appointees at the level of the Attorney General to deal with the virus and menace of corruption. Now you are narrowing your loyalty to just the Special Prosecutor Act. Is that my understanding? Or to the state of Ghana?
Loyalty to the law, the laws of the Republic of Ghana, the Republic of Ghana.
Thank you, Chairman.
Honorable Nominee, apart from page 1, your biodata, page 2, everything talks about law. Page 3, employment history, law. Page 4, law. Page 5, law. Page 6, leadership and positions, law. Page 7, in fact, even a Kwafu Hall Junior Common Room, legal secretary, law. Conferences, capacity building programs attended, every single one of them, law. Publications, law. Selected papers, law. In fact, honest, notary public, law. We have one football activity passing through. Mr. Chairman, I want to find out from the nominee, do you have any other life? What makes you happy?
Reading the law.
Honorable Chair, what makes me happy, I cannot disclose on my CV.
Is that the answer to the question? You have to be a well-rounded person.
Honorable Chair, what I mean to say is I'm very well-rounded. Just that the CV came with guidelines. So I tried to follow the guidelines of the House. But what makes me happy, the guidelines did not capture those things. So I couldn't put them there. But Honorable Chair, I signify that I like walking. I like to trek mountains. I climb a lot. So at least that's some social life. Being from a mountainous area.
Mr. Chairman, on a lighter note, the nominee said he was from Kwewu. I know him to be from Kwewu. But he made a mistake by saying that his favorite Kwewu food is fufu and nkakra. The Kwewu food is fufu and decolonized apine.
Honorable Chair, I didn't want to cause an uproar by going there. But correction duly noted.
Chairman, thank you, Mr. Chairman.
What did you say? Decolonized apine? Is that the one they call Air Force?
It's decolonized apine, but fufu and decolonized apine.
I see. That's right. Yes, that was really.
Thank you very much, Honorable Chair. Honorable Nominee, it's on record that I had some reservations with regard to your predecessor, but I had nothing wrong with, I had no reservation as far as his politics was concerned, because I was very confident that he was not going to be easily swayed by partisanship. So I didn't have a problem with his politics. On the contrary, in your case, many don't seem to know your politics that much. But so many people have expressed reservation about your possible partisanship. And I'm sure it's only time that will indicate if there are reservations, will hold water. I'll start on that note, therefore, to ask if you get invited and do attend meetings of leading New Patriotic Party members to discuss what you may call high-profile partisan complex legal cases.
Which are you saying I have been or I am going to be invited?
Do you get invited and do you attend?
No, Nabucha. Okay. No to both.
Now let me take you back to an earlier question relating to what you refer to as an academic paper that you presented with regard to the 2012-2013 election petition. I have gone through the paper, and I just wish to share two quotes with the permission of the chairman. First one, quote, "If the pink sheets were so unreliable, will they form the basis for the declaration of a president?" Unquote. Second one, "I want to tell their lordship," that's quote, "I want to tell their lordship that it is not merely easy to say that by some rebuttable presumption of evidentiary setup that official acts are presumed to have been validly done. Therefore, the figures as provided by the EC are presumed to be correct, especially where in this case the EC itself admitted, though tenuously, that irregularities were recorded in respect of the elections." Unquote. Now, based on these views, and based on the knowledge that, for example, the Electoral Commission in their final declaration declared multiple results before they finally, came with the last one. What is your view on the outcome of the 2021 petition in relation to how the Electoral Commission was presumed to have done the right thing, given these two quotations especially?
Now, there were dissimilar circumstances, once again. In respect of the first election petition, those quotes emanated from some pronouncements of the judges, some of the judges. Some of the judges went to say that the pink sheets that were brought to court were so unreliable they couldn't do anything with it. That was my understanding of what they were saying. So I was asking a question. That if the pink sheets, which forms the basis for the declaration of a president, that you saw in court, are so unreliable, how then do we have a reliable outcome? Because that is the primary document, if I'm not mistaken. And then the presumption that the official acts are presumed to have been validly performed. This is when the act has actually been performed. Then you come out with that presumption, and anyone who has issues with it will then come trying to rebut it. But in respect of the 2012 election petition, the official act I was referring to had not been performed. And this was it. The refusal or neglect of some of the returning officers to sign on the returns. The act hasn't been performed. There is an absence of a person's signature there. So if you go ahead to say official acts are presumed to have been performed, I was at pains to understand and wrap my mind around as to how that presumption can be raised here when there is no signature. So I actually said that. Did we bother to find out from those returning officers as to why their signatures were missing? In respect of the recent election petition, that's a totally different matter, in that an act had been performed. The allegation was that it wasn't performed well and that there were infractions. Totally different situation from where the act wasn't performed at all. Now, if you come to the conclusion in respect of the recent one, that though there were some mistakes, though there were infractions, but you can still make sense of what occurred, that to me is a different matter from where the act wasn't performed and you are raising a presumption on it to come to a judicial conclusion.
Well, I only litigate it further. I'll move on, just except to say that just like the unreliable pink sheets, it perhaps would have been appropriate if you are minded to comment on it, for the Electoral Commission to defend whatever errors happened until, the final one, and not for the judges to presume that what was finally declared was the one to rely on. But I don't want...
Are you referring to the trial strategy?
Yes, partly so. But like I said, it's not. I don't want to litigate it further. I will just move on to my next question so that I'm not, bailed out by the very generous chairman this afternoon. Another question that you were asked by Honorable John Kumar. I would want to do a quick follow-up on that. You have worked closely with Anas Amiriya Anas. The president, in opposition whilst campaigning, promised to use a principle he christened Anas principle to fight against corruption once he was elected. Unfortunately, we haven't seen that. Indeed, some of his leading members have rather been on a warpath and have gone to great length to discredit the Anas principle. And in fact, even in the question, it's not one person, even the question of John Kumar, he talked about school of thoughts. And one of the thoughts was to say that that method of gathering evidence is not to be admitted. So it's not one person. So I'm saying that they have gone to greater length to discredit that principle. Knowing your relationship with Anas Amiriya Anas, you have defended that principle in court. Now, your office will require that you gather information, you do investigations. Since the president has failed to implement this principle and have had some of his members criticize this principle, is it a principle, and you have worked in defense of that principle in the past, is it a principle you will consider to use in your fight against corruption? And can you count, or do you expect the president to fully support you on this?
Honorable Chair, as I quickly reminded an earlier questioner in respect of the Anas principle, and that was clearly an indication that I fully subscribe to that principle, and I'm going to use it. Indeed, I also said in an answer to a previous question that I will be engaging investigative journalists in respect of my work if given the nod. I say so because I have intimated that corruption is so secretive and complex, and that unless the participants are coming to you to report themselves to you, it is almost impossible to find it out. Now, if someone can go underground and through a sting operation come out with some evidence which has probative value, I am all for it, and I'm going to use it. I hope I've answered your question.
There's a second part. Given the attitude of people close to the president in relation to this principle, can you count on the president and his government's support?
Upon my consideration, I had full assurance. It is one of the reasons why I'm sitting here, that I'm going to count on his full support in making this office successful, making it work, making it effective.
Well, your predecessor told us the same thing.
As I keep saying, I won't be wearing his shoes. I'll wear my own shoes.
I'm just putting it on record that he told us the same thing, and now he's saying something different. So I wish you well, though. Finally, you spoke of Article 88, 3 and 4 of the 1992 Constitution. And that got me thinking. Corruption is a high-risk, enterprise. And to fight it, one will need to be very well prepared, because those engaged in it will go at any length to frustrate the fight. Now, you suggested in that answer that the OSP may be unconstitutional, because you talked about the need to clean house because of the, especially 88.3. Why did you accept to use this tool that can be challenged by those who may see it as a threat?
Honorable Chair, I was by no means suggesting that it's unconstitutional. I was just admonishing that we need to make things clearer, and not just in respect of the Office of the Special Prosecutor, in respect of the other agencies too. That was my call. I'm never suggesting that it's unconstitutional. I said the concerns I had initially when this process began as a bill and all that, I communicated to the Attorney General then unofficially. And those concerns...
And you said it bordered on the constitutionality of the office. I quoted you.
Yes, the constitutionality when it was mooted, not the constitutionality of the outcome, which is Act 959. They are different things. My concern was that if care is not taken, the Attorney General will be upstaged, judging from Article 88. And so, in order not to upstage the Attorney General, certain provisions ought to be added to flesh it out, to keep Article 88 as it is, whilst adding to it Act 959. And largely, that has been achieved in Act 959. But I was saying, the cleaning of the house, I was referring to that a bit more work has to be done to make things clearer. As I said in relation to an earlier question, the mother problem is 88.3. If we are able to dovetail it better, it will make things work more effectively and efficiently. So it wasn't a suggestion that 959 is unconstitutional, in my opinion. Not at all.
Okay, can I suspend sitting for 10 minutes?
And you heard the Special Prosecutor Nominee Kissi Agyebeng answering some questions before the Appointments Committee in Parliament. This just taking a break and we'll take you back there. But we continue with regular programming. Thank you so much for your company. There's more news when you log on to myjoyonline.com. Do stay with us. We are your home of independent, fearless and credible journalism.